Ladies and gentlemen, welcome aboard to Compliance Global Link Live webinar session on HIPAA training enforcing protection for PHI and ePHI, all that you need to know. My name is Esther and I will be your host for today's session. On behalf of the entire Compliance Global Link team, I would like to thank you for being part of today's webinar. Today's webinar is presented by Mr. John Garner. A few words about John before we start off today's session. Mr. Garner is a compliance officer at Bolton & Company. Before joining Bolton, he was a principal of Garner Consulting in Pasadena, California. Prior to founding Garner Consulting, he was a principal in the Los Angeles office of Tower Pennerid, where he worked for over 10 years. Mr. Garner serves as the National Legislative and Government Affairs Advisor for the Disability Management Employee Coalition. He is a past chair of the CEBS Committee for the International Foundation of Employee Benefit Plans. He is a past member of Governing Council for the International Society of Certified Employee Benefit Specialists and a past president for the Los Angeles chapter. Mr. Garner is also a past president of the Employee Benefit Planning Association of South California, the Los Angeles Life and the Accident Claim Association, and the Western Claim Conference. He is the author of the Health Insurance Answer Book and the article that have appeared in numerous publications. Mr. Garner received his BA degree from the Residential College. He is the Chartered Life Underwriter, a Certified Employee Benefit Specialist, a Group Benefit Associate, Retirement Plan Associate, a Certified Management Consultant, and a Certified Flexible Compensation Instructor. We're distinguished to have such an expert like John to present our webinar today. Let me give you a quick outline on today's proceedings. John will first take us through a webinar highlighting the areas that would be covered in the session and then his main presentation. I would like to inform all attendees that once we begin the teleconference, all phone lines will be placed on mute and will remain so until we begin the Q&A session, which is going to take place towards the end of the webinar. This is basically to avoid a discontinuity and to make sure all participants attending the program benefit from the same. Now, if for any reason, if you get logged out during the session, please join the session using the same procedure. Now that we're all ready, I would request John to take it forward from here. Over to you, John.
Thank you, Esther. I want to add my welcome to everyone on the webinar today. First, let's go over the agenda for today. We're going to start with what, depending on your prior experience, will either be an introduction to HIPAA privacy and security or a refresher on those topics. We're also going to talk about the HITECH Act and the regulations under that act. And we're going to close with some guidance from the Department of Health and Human Services regarding mobile devices. And then we'll have questions at the end. So first, with regard to HIPAA, as you probably know, HIPAA stands for the Health Insurance Portability and Accountability Act of 1996. Congress said if we don't pass legislation regarding privacy and security, it's up to the Department of Health and Human Services to issue regulations. They never passed legislation, so almost everything we have is from the regulations rather than any statutory language. We have covered entities under HIPAA. These are entities that have to comply with HIPAA, and they fall into three categories. There are health plans, healthcare providers that conduct certain types of transactions electronically, and healthcare clearinghouses. Clearinghouses are entities that either take paper from doctors and transmit it electronically to health plans, or take paper from health plans and transmit it electronically to providers. The regulations are the same for all three entities, but of course certain parts of the regulations have more applicability to certain types of entities. And when I say health plans are a covered entity, you may be thinking, oh, okay, health plans, that's like Aetna and the Blues and Cigna and United, and that's true, those are all health plans, but it's more than that. It includes employer-sponsored health plans. So the ABC Company Health Plan is a health plan under HIPAA, and there's no minimum size requirement. You could have Joe's Barber Shop with 2 employees. If they've got a health plan, they're subject to HIPAA. Now, if the plans are fully insured, they can lay off a lot of the responsibility onto the insurance company. But if there's any self-funded elements, and that includes just a flexible spending account or a health reimbursement arrangement, then there's a lot more responsibility that falls on the covered entity. And so I jumped ahead of myself. We do have an exception for self-funded, self-administered health plans with fewer than 50 participants. They're excluded. So this would typically be something like a health reimbursement arrangement or a flexible spending account. Not many employers with fewer than 50 employees self-fund their regular medical plan and self-administer it. And the definition of medical care is very broad. We're not just talking about medical, but we're talking about dental and vision and prescription drugs and mental health, health flexible spending accounts, executive medical plans. There are some gray areas. Employee assistance plans, EAPs, are a gray area. If the plan provides significant medical care, then it is a health plan, and it's subject not only to HIPAA, but also to ERISA and COBRA and healthcare reform. We do not have a bright line test on what is significant. I would argue that if a plan is only providing 3 visits, that's probably just doing assessment and referral. 8 visits, I'd say you're in a gray area. Certainly over 10 visits, that's significant, but we do not have a bright line test on that. Similarly, another gray area is on-site medical clinics. If all you're doing is providing first aid when somebody's injured on the job, that's probably not a health plan. On the other hand, if the plan, provides flu shots to all employees and their dependents, that may very well be a health plan. And if it provides all kinds of ongoing care to employees and retirees and dependents, then clearly it's a health plan. And if the plans are engaged, if the clinics are engaged in certain electronic transactions, then the clinic would be a provider and would be subject as a provider. So what is it that covered entities have to do? Well, there's a lot of things they have to do. This is a brief summary. First of all, they have to provide privacy notices to either plan participants or patients. They have to adopt security policies and procedures and privacy policies and procedures. They have to appoint a privacy officer and a security officer. There has to be a grievance procedure. Health plans have to amend plan documents if they want to have access to certain protected health information. Employees of the health plan or the provider have to be trained with regard to HIPAA, and there has to be periodic retraining, although we have no guidance as to how frequent or how extensive that has to be. And covered entities have to safeguard the uses and disclosures of protected health information. Now, it's also important that you understand who is a business associate. Business associates are not covered entities, but they are a person or an entity who is hired by a covered entity to perform a function or activity on behalf of the covered entity, or to perform one of a list of specific services for the covered